arts training and his opinions on use of force. Williams is someone you'll recognize if you've seen any of the body camera video from this incident. Take a look.
Bro, look, well, you should check on him. He's not responsive right now.
Back off!
He's not responsive.
Get off the street before you run. Okay, then you wouldn't know. Get off the street.
He's not responsive right now. He's not responsive right now, bro.
Does he have a pulse?
No, bro, look at him. He's not responsive right now, bro.
Check for a pulse.
Bro, are you serious? He gonna just let him sit there with that on his neck,
Let me see a
bro?
pulse.
Is he breathing right now? Check his
How long
pulse.
we have this conversation?
Check his pulse.
Okay.
Check his pulse, Tal. Tal, check his pulse. Tal, check his pulse, bro. Bro, check his pulse, bro. You bogus, bro.
Don't do
you
drugs,
bogus.
guys.
Don't do drugs, bro.
Exactly.
What is that? What do you think that is? You call what he doing okay?
Get back
You
on the
call what
street.
he doing okay?
A very dramatic scene. Colleagues Julia Janae, Julie Grant, and Michael Ayala all here to break down what happened. And we're going to start, Michael, with this one. But before we do, let's take a look at how Motion 22 was presented.
Number 22 of the defense motions is prohibiting a witness by the name of Donald Williams from testifying as to his martial arts training and various components, opinions that he's made relevant to the use of force used in this case by the Minneapolis Police Department. Mr. Williams was one of the civilian bystanders who was captured in the widespread Facebook video, who in the course of that video was wearing a Northside Boxing Gym sweatshirt. He has made several statements to investigators detailing his training as a mixed martial arts fighter, wrestler, things of that nature. And he offers opinion as to the move that was used, or the purported move that was used by Mr. Chauvin in this case. So what we are asking the court to do is to limit or exclude his opinion. I do not believe he can be qualified as an expert in this particular case. For the record, I am not suggesting that he cannot testify as to what he observed. Clearly, he was a bystander. He was there. He was present. What he saw, what he experienced, those are all, again, legitimate areas.
All right, Michael Ayala, to you on this one. Williams says that he was watching Chauvin and he used what he called a blood choke, and that he knew it was a blood choke and he tried to stop it. The judge, Judge Cahill, is saying, you know what? He does have some expertise here. He can testify to some extent on this.
Yeah, you know what? I'm a jiu-jitsu practitioner, and I can tell you that learning chokes is the first thing you learn, and you learn them, and you learn them, and you drill them, and you really get to understand how to accomplish that in the proper way. So just watching someone putting a knee on a neck, you can see that that person is putting the knee in a place that they know would be most effective. That's on the carotid artery. That is what you're working with. That's what cuts the airflow to the brain. And you could see that he thought, at least, that the knee was placed in what they call a blood choke, and that means you're cutting off the flow of that carotid artery, and that stops the oxygen to the brain, which could knock somebody out and eventually kill them, cause brain damage, do a number of things. And these are things you learn. So the fact that he's going to be able to testify to that, I think, is appropriate. I was happy with the judge's decision. I think he's going to give his background to this jury, and the jury can make a decision as to how they are going to weigh what he testifies to. But he's going to limit him to testify to what he saw, not to the effects of what he saw, which I think is appropriate.
Yeah, saying that you could say this is what I thought was happening in my eyes, but the ramifications of what happened he can't get into. A lot like we saw with the argument yesterday with the firefighter. Julia, that brings us to motion 23, and that firefighter's name is Genevieve Hansen. Now, today we heard some focus on the paramedics who will also be testifying. They came on scene, and Judge Cahill basically says same thing. You could talk about what you saw, but not what you think.
Exactly. This has to do with the paramedics and members of the fire department who were on scene, and they were there trying to resuscitate George Floyd, but the defense said they didn't want them to get into either the cause of death or any contributing factors. And the judge did rule that they can talk about the symptoms. They can talk about their attempts to try to save his life, the things that they saw, the things that they perceived, but they can't get into the medical part of it. Basically, the things that the medical examiners and experts who will be on the stand will testify about. What actually caused the death and what was the manner of death. They have to stick to the same thing that the judge ruled on Genevieve Hansen, that off-duty firefighter that we see in that video who's standing next to Donald Williams. She has made statements in the media that she could have saved George Floyd's life if she had been given the opportunity. That went beyond what the judge says she will be allowed to testify. She can't talk about whether or not he would have survived, but only about the symptoms, what they observed, and those attempts to save his life.
All right, Julie, the next motion that they talked about this morning was motion 33, and it centers around this idea of spark of life, and that is testimony that brings a deceased victim sort of to life in a courtroom, talking about their background, they're the father, mother, or good person, bad person-ish, but you can't go too far. And in this case, the judge was very sensitive in terms of what can and can't be said about George Floyd.
Yeah, most definitely, Ted. You know, I looked up that spark of life idea, and this is something particular to the state of Minnesota, right? So if our viewers at home are going, well, what exactly is that? What kind of testimony is that? This is something that's specific to Minnesota law. And essentially, just like the name says, spark of life, it's giving life to the deceased, right? Because under the law, in a homicide case like this one, the law recognizes that we don't just want to look at the deceased as only that. This was a human being. George Floyd was a person who was living a life on this earth, and that needs to be acknowledged through some testimony, albeit limited testimony, right? Because we know that in both criminal cases and in civil cases, character evidence is limited. We can't just have a trial talking about how wonderful any particular human being was, because that would be unfair to the opposite side, right? So here the judge is being very sensitive to that certainly we need to know about George Floyd's life, but a limited amount. And the state can't, they have to be very careful not to open the door to try to put forth good character evidence, because then the defense could rebut that potentially. And so we know there have been some other motions in limine that have been argued pertaining to that 2019 arrest, for example. You know, they can't open the door because potentially then the defense could go to the judge outside the presence of the jury and say, hey, look, they went a little too far with this spark of life testimony, and now we need to have a chance to refute some of that with some other character evidence. So I think it was a good ruling by the judge. We need to hear about George Floyd. We need some life to be given to him before this jury so they can see the kind of individual whose life was lost here.
Yeah, and the prosecution was told, don't call him, because a lot of people that knew him called him a gentle giant. And Judge Cahill says, stay away from the word gentle, because that will open up the door for potentially bringing in some of his arrest record, things that he did have on his record. And the prosecution was smart enough to say, all right, when we get there, we're going to ask for clarification, very, very specific clarification, so that no doors are open. We're going to step aside, take a break, say goodbye to Julia Janae for now. She'll be here with us throughout the afternoon. But Julie and Michael will be back with me, and we'll talk about the jury and the prospective jurors, get their opinion on what we've seen so far today, right after this.